In this video, I'm going to be talking about criminal recklessness in Indiana and how you beat a criminal recklessness charge. For a lot of people, you may not be sure what you should be doing if you're facing this charge, and what you find out is if you do your homework in the beginning and learn more about the offense and what's going on and how to prepare, you can get a better outcome in the end. So about me, my name's Nathan Vining. I'm a criminal defense attorney here in Indianapolis, and I represent people charged with different criminal offenses throughout the state of Indiana. By the end of this video, you should know more about criminal recklessness in Indiana. So in any criminal case, one of the first things you should do is look at the statute that you're being charged under. Criminal recklessness is charged under 35-42-2-2. And what it does is defines criminal recklessness as recklessly, knowingly, or intentionally performing an act that creates a substantial risk of bodily injury to another. Penalties for criminal recklessness vary. The lowest penalty is a Class B misdemeanor. It can also be charged as a level 5 felony if it's committed by shooting a firearm into a habited dwelling or in an area where people are known to be. While this statute outlines recklessness, it doesn't explain what recklessly means. So you need to turn to Indiana case law to determine what recklessly means. So most crimes we talk about, they have an intent element. This means that you intended to do something. With recklessness, there isn't that need to intend the result. The person must do something with a disregard to the harm that might result. And courts have said that it is sufficient to show that the person realized or should have realized that there was a strong possibility that harm might result. So an example of criminal recklessness could be texting while driving, dropping a firearm and having the firearm discharged, firing a gun in someone's direction, pointing a gun at someone, or shooting a gun towards a residence. So at the low level with criminal recklessness, if you're charged with a B misdemeanor, that could mean 180 days in jail. If it involves a weapon, the level 6, the penalties would range from 6 months to 2.5 years in jail. At the highest, a level 5, the penalties would range from 1 year to 6 years in jail with an advisory of 3 years. So if you're charged with criminal recklessness, what could a potential defense look like? The first thing I recommend doing is looking to see if the conduct is reckless. The goal would be to show that the conduct did not rise to the level of being reckless. An example of this would be that you're charged with recklessness for firing a weapon, but maybe at trial you could prove that you fired the gun across a vacant lot. Courts have found that this act only presented a remote chance of bodily injury and that a car could be passing by at that time. So that conduct, firing across an empty lot, didn't rise to the level of recklessness. Another example would be falling asleep while driving. Falling asleep alone without any other tangential evidence that would show why the conduct is reckless isn't recklessness. There needs to be some part on the person to show that maybe they disregarded the fact that they were tired. There needs to be some kind of specifics as to why the state believes that conduct is reckless. So without specific evidence, the recklessness standard could be hard to prove. Another thing that I recommend doing in a criminal recklessness case in Indiana is looking for witness issues. Sometimes these cases can be a he said, she said kind of case, so you need to take everybody's taped statements to see how the story develops through discovery. There could be missing witnesses, credibility issues, or a different story. You need to explore all these avenues because a lot of times what you have is one party to a conflict stating one version of events happened, and you have the other side of the conflict stating a different series of events occurred. So through doing discovery and tape statements or depositions, you can start to see if there's issues with one side of the case. Another thing you can do if you're facing a criminal recklessness charge is to consider doing some mitigation. What this is it would be evidence of things that you're doing to help improve yourself, to show the state or the judge why maybe incarceration or jail wouldn't be the best result in your case. An example of when this could be helpful is if you're involved with a case with a shooting or a firearm. Something you can do is start associating with different groups of people, get family support. If you're not working, you can get a job, or if you're out of school, you can get into school. So if you're facing a criminal recklessness charge, you may have questions that need answered, and you may want to go over the facts of your case with an attorney. And if you need help with anything with that, I'd be happy to review your case, pull up your police reports, your probable cause, and work through a strategy as to what I would do in your situation. So feel free to give me a call or text me, and you can also find out more information on my website or watch more videos that I have about the Indiana court process.